My lord, your loss. Cooperative matter sitting in courtroom number 9, where your lordship was pleased disciplinary proceedings, lordship was pleased to dismiss, but lordship was pleased to, my lord, grant certain reliefs from particular date. My lord, that was not implemented. Subsequently, my lord, I have made a review application for that. For that particular date, it should be in my humble submission. A more subsistence allowance will be given to me. But my lord, in the meantime, my lord, the petitioner has also expired. That is why that was the delay. He was suffering from terminal disease. My lord, I have made a review application, section 5, subsistence, substitution application, and section.
Live now.
Yes, well, Toshima kindly decides. Amendments may be made even after appellate orders, my lord.
Amendment may be made even after appellate order is
You
one
lost
thing. It's not an appeal. It's a disposed of matter.
disposed of matter,
That's the problem.
but we are at the
If there's a
first stage.
pending appeal in the appellate stage, you could have uh, made that application. Now it's difficult. You are trying to make some new claim.
New
Disposed
claim.
of-
My prayer was, my lord. There was a mistake in the prayer portion in respect of the date, and therefore the lordship had said in the order that from this date, since it has been prayed by the petitioners, from this date he will be getting the subsistence allowance. It should have been from the date of the show cause notice. That I'll try to substantiate. If your lordship is not of the view, Mel,
Mr. Lahiri, that will be a re-argument.
lordship takes up, and thereafter, if your lordship is of the view that kindly,
It's better if you prefer an appeal.
we will not, because it has not been implemented. They have also not acted. Even the provident fund dues have not been given, and my lord, my client, my lord, expired because of, my lord, cancer.
May I have my lords? May I have my lords kindly
You
to mention
substitute
item
on
number
it.
204. I mentioned this matter last, my lord, month. My lord, this is
204.
yes, my lord, the
Supplementary list.
of the daily supplementary list. My lord, the challenge, my lord, in this application is directed against an appellate order by which my appeal has been dismissed on the ground that delay cannot be condoned. The my lord,
Appellate order under which
my lord,
provision?
Urban Land Ceiling Act, the authority under that act. My lord, ignoring the provision of section 33, the proviso which says that it can be granted. My lord, I don't want an adjudication from your lordship. I just want, my lord, lordship considers whether the condonation of delay power was there under the act and remand it, my lord, to the.
Where is the other side? It's the state.
My lord, I will give notice to the legal remembrance. My lord, that is how it's being done now.
Sir, so now the panel is not there. Who will represent? Even the legal remembrancer cannot appoint someone.
My lord, may I try my luck?
After the panel is prepared, then because you have also to serve a notice.
No, I will try and serve. I will serve the, my lord, authority concerned also.
A copy of the writ petition also.
Yes, I will. I have served that. I will serve again.
Yeah.
I will serve again,
Yes.
and I will take my lord chance. Lordship gives me one day, my lord, next week. If there is nobody, lordship will not pass an order. I will not.
After the panel is prepared, please serve upon an advocate. Then mention. I will consider.
But that will, my lord, take it up, my lord, beyond the vacation, my lord. I was hoping, my lord, to get an opportunity this side.
If you can get someone, then otherwise no use.
So, my lord, I was only praying this, subject to my lord, agreeing to this. My lord kindly gives me that liberty to, my lord, have this matter listed any day. I will try to serve and come back. If lordship does not find anybody, then I will not move it.
I will do so. Please serve, because every day this matter is being called on.
Very well.
Entire list.
Let
Yesterday
me-
also it was
let-
called
let-
on. So you
Yes, I
can
will
take
try
your
to-
chance
I
today
will.
also.
I will again, my lord, try and get hold of somebody. If I can, then lordship kindly accommodate.
Because yesterday also the entire list was called on.
Sir, may I permitted to
Yes,
mention,
because
sir,
my junior Mr. Shonak Mukhopadhyay appeared once, but state was not there.
Yes. So
Sir,
unless the state is there, it's difficult now.
Very. I'll try. I'll try to.
Previously, it could have been done even in the absence of the state. Now the panel is not there. The request is being made.
Very well. Very well.
Probably from the next week something will be
Very well.
happen.
My lord, may
My
I
lord,
permit to
my lord,
mention
this
the-
is not regarding this matter, my lord. Can we expect the judgment, my lord, in that order 13A which lordship has
Yes,
written?
yes.
Agreed.
my lord, upgradation of my lord contempt application in connection with my lord CO matter, my lord. The civil revisional application, my lord. And the
Contempt.
yes, my lord. They have undertook, my lord. They will vacate the property, my lord, within my lord 28th of February, my lord. They
What is
failed
the item number?
608, my lord.
608 টা কালকে update করুন।
I'm very grateful.
Yes. Anyone appeared for the alleged contempt or it's the first time?
First time, my lord.
There was no direction to serve.
No, my lord. But tomorrow, my lord. I'm good.
Yes.
I'm seeking to file a leave of matter, my lord. Demolition notice has been served upon me, my lord, on 5th June, my lord. I'm challenging this, my lord, and 20
Notice under what provision?
notice, my lord, 10th, 10A of the High India West Bengal
10?
Highways, A of 10th 1A of the Highways Act, my
10
lord.
1 or 10 3?
10 1A, my lord.
10 1A. Do you have the copy of the notice?
My lord, 10 1, my lord.
10 1, nothing.
My lord,
Yes, sir.
kindly keep it on Monday, my lord. 20 is the last date, my lord.
Have you read the provisions?
My lord, yes, my lord, kindly, my lord.
10 1, if you don't comply,
Well,
there
I've
are
been
other
li-
provisions which is to take place.
My lord, I've been living here for 30 years with my family, my lord.
That's a different thing altogether. Have you served the state?
No, my
What
lord,
is-
no,
If
I've
you
not.
serve the state, then mention. Yes, call the list.
This is, my lord, only a formal order of reconstruction may be made because the file has been, my lord, I have given all the Xerox copies of everything. It was last heard before the Honorable Justice, Honorable Justice Bivas Patnaik.
Then the file was there.
And the file was there. January 2025 file was there.
Then
Thereafter, in the transit lost. I totally remember I went and did the matter. His Lordship was sitting in that building, Centenary building. Writ petition and report. Twice report was filed. This is the next report that has been filed. Same report. First is 2014 writ petition. Once report was filed, thereafter in 2021, everything changed. Again, I served. Again, a report was filed. Point is very simple that after the grant of probate, whether they can claim the amount of fees for transfer fees for mutation. Kindly seize the impugned order. Now, some months ago also, it has again been settled by the Honorable Division Bench, though there is an order which was passed by.
where is the, did you file any application for reconstruction?
No, well, this is no application for reconstruction. It
File
was
any
no,
application.
because it is a departmental, well, finding. I think the department has given a note, Mallet. I think there was a communication to the registered administration, and thereafter reconstruction was, Mallet, made. এটা অন্য একই।
It was directed to be placed before the registered administration Lojima.
I দেখি চিঠিটা দেখি 26 আমাদের চিঠিটা 5 তারিখ
Yes, so it has been directed to be placed before the register administration. I'm directing the matter to be placed before the.
And item number 2, pursuant to your lordship's direction, we have tried to serve the government trader, but the office is not taking up the services.
That is why I told you please do it after.
This is that matter, the compensation, a lady, that everything
The
was done, but
uh, we mentioned আছে তাহলে after the meeting on
কবে ওপেন হচ্ছে?
8 তারিখ 9th of June. Yes.
May it please, my lord, this is the matter where your lordship had asked Mr. Wasim Ahmed to come and submit the report, which is
Now
before
the
your
report, for
lordship,
the purpose, now you are having the report.
my lord.
Sir, but
And this report entails that the petitioner gets a constitutional protection because the two machineries of the state, they come up with contradictory statements. The police says, police authorities, they say that we have taken possession, we are constructing. And the acquisition officer comes and says, we have not acquired the property. This property is not subject matter of any acquisition proceedings.
where is the report? Please show
My
me.
lord.
Status report is of 8th of December 2025.
That was the first report filed by the police authorities.
But no, this is the special land acquisition officer.
That should be 26. I
It's
suppose.
9th of December 2025.
Kindly bear
It was
for
submitted on the last.
my lord. 25, my lord. The status of LA proceedings, your lordship will find the second one. From the available office documents and records, it is found that the plots mentioned in the writ of the instant case of Moza such and such, District 24 Parganas, are not involved in any LA proceedings. Therefore, the question of acquisition and payment of compensation does not arise for LA department in this regard, as the land is not acquired under any land
That is the
acquisition
report of
proceeding.
the police.
My lord, they say that the property has been handed over. Your lordship will come to the last paragraph of the first page, your lordship.
So what is the date of the police report?
My lord, that is 12th of June 25.
Yes.
The last paragraph in this regard, this is to state that the land measuring 2.28 acres in RS Dag number 71 full was handed over to the officer in charge, building section, Kolkata Police. Under what authority of law has it been handed? So they say a writ of possession has been, by virtue of a writ of possession. That is an administrative document, my lord. And without any acquisition proceeding, if for administrative convenience property is taken, that violates the Article 300A of the Constitution of India, my lord. And in such an event, the petitioner is entitled to a protection, which in my most humble submission should be a constitutional protection because it violates Article 300A.
Yes, can you ask Mr. Dhiraj Trivedi to come?
My lord,
Please, I'm passing it over.
my lord.
Let's ask Mr. Dhiraj Trivedi to come.
If he's in the court, because these days he's busy either in Navan or Governor House. I'll just give him a call, my lord.
He's present.
I'll just indicate, my lord.
The password.
I am appearing for the petition.
Yes.
Someone here, your lordship kindly see. Take it one, right? Lordship's last.
In-house fight.
Your lordship's last
In-house
order.
fight.
Receiving end.
In-house
In-house
fight.
fight, receiving end.
In-house fight. Now, your lordship kindly see, last order dated
Original.
9/4/2026. In this order, there are two parts. One part, they have already admitted that the number 20% to whom they have not given the rehabilitation because the person concerned has died. We pray for the rehabilitation of the new nominated person by the land loser. That Mr. Pan last time says that he has no instruction. Whether he has any instruction or not, that. Regarding second portion of the order, I have prayed for
gravely করতে হতো
amendment of the writ petition, incorporating certain prayers and facts.
He has filed an opposition.
Oh,
Opposition to amendment.
we have filed our amendment application in the department. On the day itself, your lordship has given the date on 21st April. 21st.
So he has filed an opposition. Have you filed a reply? Reply to this
My lord,
amendment.
this has been given yesterday, late evening, and also not legible copy. Your lordship kindly see.
Not legible copy, Mr.
Not
Pa.
legible copy. Your lordship kindly
That
see
is the
what
power
copy
of
has,
attorney.
Then
That is the last.
I will not accept this.
not legible copy at all. I cannot read
Sought a
it.
legible copy to Mr. Chatterjee. I will not.
I
accept.
cannot read it.
By course of today, by course of it's a matter power of attorney. Last
Maybe.
page is not legible. It's what the
Don't
power of
annex
attorney.
that then. If it is not
I will not
necessary.
delight. But I will not delight. I will power of attorney. I will not delight.
Now he says no, not.
Yes.
But he has said something in the power of attorney in the body of the petition.
Sir, Pan, give a legible.
Yes. I will. By
Let
course
him-
of by
let
course
him
of
supply-
tomorrow. I will bring from the Asansol. By course of tomorrow,
Let-
I'm giving an undertaking that I will supply a legible
well.
copy of the power of attorney. My lord, so far the merit of the matter is concerned is nothing to do with this power of attorney. My lord, in the guise of amendment, my lord, he is
Then you have
trying to
annexed
reissue
this.
the which has been settled up to the Supreme Court.
That's a different thing. When
Well,
you have annexed
That
a
is the
document,
subject
Yes,
matter of
he is entitled to eligible
I go
copy.
down to your lordship. I go down to
The
your lordship.
copy which you have
But-
annexed, I cannot also
No,
read.
no, no. I go down to your lordship. To by course of tomorrow, I will.
Just now I asked Mr. Pan whether the copy has been served on me, has been given to the honorable judge. See, he did
Same
not
copy.
answer. He did not answer. Yes, same copy.
I feel bad because of it. I feel bad.
How much
reply
time
to
you
the-
want to file a reply?
We are opening on 8th. On 12th?
On 12th. Mr. Pan, when we can give tomorrow or Monday?
No. By today itself, I will give. But for the precautionary measure, my lord, by tomorrow I will hand it
You
over
give
to
out Monday?
No. আজকেই দিয়ে দেবো তোমাকে আমি আনিয়ে নিচ্ছি
Saying that by
By course of
Monday,
tomorrow.
by Monday,
My
do
lord.
it as early as
my lord.
the affidavit in
I've been briefed to oppose. Worship this
To oppose.
my lord. The matter is, they have got a public.
That is evident from the place you have chosen.
My lord, the state officer hearing is on the 18th. I've been briefed yesterday. I've been briefed really today morning. Lordship Kali keeps it tomorrow. This is going to have.
Mr. Mitchell,
I've seen my lord.
yes, because there is another proceeding. So that's pending before another coordinate bench. So maybe Mr. Mujumdar is saying it has some relevance with this. Your stand might be it does not have any relevance.
Lordship has to be prima facie satisfied.
Only
What?
thing is the property is the same.
Property
Is
my
the
lord,
same, but the issue may not be the
property is also not the same, as in that involves 140 bighas of land
a portion
all
of
along the Strand Road, where there are hundreds of eviction other cases pending. Now, if for any of these, now this will become have very far-reaching consequences. Any of the cases, wherever there is eviction, now they will come and say, "I'll be heard with the writ petition," because this is, after all,
I'm not saying it will be hard with that writ petition. That is not there.
or
I
that
only
court could
wanted
hear.
that bench, when that bench is in
So,
sitting now.
so if I go to estate officer hearing, because after Lordship is exercising the same powers as the estate officer. Estate officers in other 100 cases, they will say you have to take the estate officer's case has to be before the writ court, because otherwise how can I proceed? Well, Lordship, only I'm saying, can you keep it
All right.
tomorrow? Mala, can you
So,
keep it tomorrow?
Monday is the date fixed.
So, Lordship, can you keep it tomorrow? I will come and make my submission tomorrow morning, because I will also get ready. Can you keep it tomorrow
Yesterday, the
morning?
understanding was my learned friend would come with the instruction as to whether they are agreeable to adjourn the hearing till the
No,
15th of June.
That's why I'm saying, can you
It is,
keep it for tomorrow?
Sir, it's only one thing. If I keep it after the vacation, I'm not saying anything. Can you adjourn the hearing
Hello,
till
Malad.
after the vacation?
Okay, all I'm saying, can you keep it for tomorrow? Because tomorrow and today makes no difference, because Monday is the hearing. So that's why I'm saying, can you keep it same
But
position?
that was also my submission. I had been a tenant for the last 91
Same
years.
position tomorrow morning, that's all I'm saying. Same position tomorrow morning. That's all I'm saying. Tomorrow I will.
Instruction আসবে adjourn করবে কিনা hearingটা।
I appear for the petitioners. I'm led by Mr. Bhattacharjee.
Wrongly filed under group 9. Yes.
Now, at page 23, a notice was issued.
Under?
I don't know under which provision. I couldn't understand. They have referred certain section has.
For the Union of India is also not appearing. What is happening? State
Because of this notice, Milad, because they do not want to follow the law.
No, not in this matter. I'm telling state is not appearing. Union of India is also not appearing. What has happened?
Now they have joined together.
Union of India is also not being represented. Now, yes.
Well, this is our apprehension, Milad. This notice has been, Milad, pasted in a wall.
Where is the notice?
At page 23. Nobody has signed it. There is no memo number. Only date is there.
Within 48 hours.
Within 48 hours, we have to vacate the place. Slum dwellers.
Who appears for the railways?
That I have to find out. What's up? Oh.
So Bhattacharjee is perhaps
Yes, leading us.
He's appeared for the railways.
No. He's leading us.
I am not that fortunate that I will be briefed by railways and the government.
Who appears for the railways?
That I can try to find out.
Now we'll try to find out, give him notice, but give us.
I'm passing it over. If anyone can be for who appears. Same panel as the Union of India or a different
That I'm
panel?
not sure. You have had a better experience.
State has stopped appearing. Union of India has also stopped appearing.
Before that court also. And that court says nothing doing, you have to do the matter.
I'm finding that the Union of India is also not being
Nevertheless,
represented.
I shall try to ask my juniors to locate who is there and bring him, but let us give a limited protection.
Can you find someone? I'm passing it over.
We shall try. If we cannot,
It's not, let me see.
okay.
It's not the same panel as Union of India.
I'm not sure. Railway is different panel. Railway maintains different panel. This is noticed by the railway.
Yes, that it's a different
Do not
panel.
give us stay for 2-3 days. In the meantime, we shall not meet the railway.
How do you ascertain who is appealing? What is this matter? Why?
This is really
Under what provision?
that is our point. They have not mentioned under which provision they have
Premises Eviction of Unauthorized Occupants Act.
that act ought to be made applicable, but it's not been applicable.
Nobody has signed, no memo number, nothing.
Mere mentioning the act would not do. And that would require the definite process of hearing. Kindly goes through. Lordship must have had the experience of going through this act number of times. Section 4. Item
So, Ahmed, when have you stopped upon the railways?
Day before yesterday. Day before yesterday. Except CRPF, who is not a necessary party. RPF. I'm sorry, RPF.
Well, can you keep it on Monday? Let us get some protection till Monday. In the meantime, we shall try to search out.
Within Monday, it will be evicted.
May not know. Have you seen? I'm sorry to say, just I had moved before the Honorable Chief Justice Public in litigation. The bulldozer culture has been imported. Nothing doing. Go out, we shall go on the street. It will invite more chaos anyway. My lord, give us a little protection.
Public premises eviction of unauthorized.
Kindly come to the text of section 4, where my lord, the procedure has to notice of show cause, then hearing, then. I just have to doubt it.
Second.
It is not land, it is public premises. What is the property?
We have the hawkers. We're hawking on the
slum dwellers.
Where the slum dwellers. We have been residing over there. They say this is
50 years.
More than 50.
And now you have to go.
No, that is what I'm thinking. If it is land,
No, even then it comes. It will come under this act.
Premises.
Yes, my lord. That was the amendment by which the land has also been brought in. Kindly come.
Premises means any premises taken.
Premises means any land to see.
Yes, means any premises belonging.
Any land or any building or part of a building, and includes the garden, grounds, such and such.
Any land, or any building.
Therefore, that was the amendment.
Because or is there. All right. I'm passing it over if Mr. Ahmed has gone to find out.
No.
Yes, sir.
I'm passing it over.
Also railway. Okay, railway.
Appear for railways.
No, he is not.
Yes, I asked you because for the state.
Mr. Dwivedi is representing state. Like in my matter, he was there. He says I am representing state.
In some matters which are very urgent, it cannot wait till the formation of the panel. That is why in one matter I have asked Mr. Dwivedi to
for abundant question and give me some space. Kindly keep it on Monday.
Yes, I will do that. I'm now keeping it at 12. If can find someone.
Yes. Railway.
Otherwise, Mr. Bhattacharya, you know that they will come and say if you are not there.
But if by any chance I am not at 12 here, kindly consider this passing interim order till Monday.
When he will be available?
I'm not sure. But if
you will be in court.
Okay, I'll be in court. Of course, Monday I will not be in court.
No. Today 12.
Today I'll be here.
Monday will not be.
Monday will not.
Tuesday,
yes.
Let me see what can be done today. The password. Yes. Yes, please take the book. Yes.
Lord, serial number 7 and 8, my lord. It's those matter, my lord.
Those were the learned advocate.
I am appearing on behalf of the corporation, my lord. Corporation request me to adjourn this matter, either my lord, learned advocate general appearing both of my lord, corporation and state, my lord.
Your lordship directed the learned AG, my lord, to produce this, my lord, gazette notification of my lord. Your lordship kindly see last order dated 16th of April 2026, my lord.
Yes, yes, that I've seen. Yes, now who will represent the corporation?
Don't know, my lord. As per request, my lord, I am praying for adjournment.
The notification,
Yes.
that is on merits I will hear. Where is that? Any notification you have found?
Everything, my lord. I yesterday, my lord, called this, my lord, law officer. Everybody will change this, my lord, to approve. Even also, my lord, corporation take time, my lord. Whether, my lord, till date, my lord, we do not find, my lord. Latest 18, my lord, require. Finally, my lord, fixed after vacation. Then, my lord.
My lord, kindly fix a date, my lord, as part heard matter, my lord.
Not part.
Yes, my lord.
Your lordship heard the matter.
An accommodation has vacation.
Well, it will not appear.
Directed to serve.
No, no, unless a date is my lord, fixed, my lord, it will not appear.
Thereafter it will appear. Yes, call the next.
Under the same heading.
My lord is supposed to deliver judgment. The argument has been completed regarding the jurisdiction of the single bench.
Oh, curtainancy.
হ্যাঁ চলে এসছে নিচে চলে এসছে No, specially fixed. Well, not we have the impression that something will happen.
Specially fixed. বড় ছিল স্পেশালি ফিক্সড করে দিলেন কেন? হ্যাঁ, সব সিনিয়র অ্যাডভোকেটরা এখন দৌড়ে দৌড়ে এসেছে করেছেন বলে। as to costs.
Grateful, Lord.
Thank you.
Why Mr. Thakkar?
No, it was a argument on the question of assumption of jurisdiction. That was a new point which was raised. I've tried to deal with that also.
Grateful, Your Lordship.
Yes.
Maybe obtain this in the server, Lordship.
Yes,
We'll
yes.
act
In
on-
course of this day.
Grateful, Lordship. Grateful, grateful.
Yes. 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 Passover. Yes. 40, 40, 50, 70,
18.
My lord, item number 18 to 22, I'm led by
That matter, my lord, if my lord recalls,
Advocate Ajay Gaggar, my lord.
my lord asked who is the competent authority. They provided a gazette that said that.
Madam, you are appearing for railways.
Yes, my lord, I'm led by Advocate Ajay Gaggar. He had to travel outside for some family emergency, my lord.
This is the Standing Council of Railways.
No, my lord, my senior is.
Has he come today?
No, my lord, he had to travel for some medical emergency, my lord. Kindly keeps it next week.
Next week?
Yes, my lord.
All right. 20.
My lord, 18 to 22.
18 to 22 on the prayer of the learned. (18 to 20, 22.
Yes, ma'am.
Just call the next matter.
Oh, আমার তো manish ko.
(24, 25, 26, 27, 29, 30, 31, 32, 33, 34, 35, 36, 37, 38, 39, 40, 41, 42, 43, 44, 45, 46, 47, 48, 49, 55, 52,
Mayor 53, I am for the petition.
55, 56, 57, 59, 60, 61, 62, 63, 64, 65, 70, 71, 73, 74, 75, 76, 79, 81, 83, 84, 85, 86, 87, 88, 89, 90, 91, 92, 93, 94, 95, 105, 107, 108, 110, 111, 113, 114, 115, 120, 122, 125, 126, 127, 130, 132,
202, my lord.
202, yes.
Lord, I am for the petition, my lord.
You are for the
petitioner.
bring this state. Yes.
24, 25, 26, 27, 28, 29, 28, 27, 28, 30, 40, 28, 27, 28.
Before rising to item number 33, I'm for the petitioner. The last of 33,
33, yes.
Last call for a report from the state. Now the situation has changed. If you can you direct me to serve further notice upon them with your lordship's last order, then the matter may be taken up in the next day.
Item number
33.
33 at file din to. Report has not been filed.
Not been filed. Shondip Rai.
Of 1995-96 and NRSA aerial map. But on the last
that they have done.
that they have done, but I will only be seeking a leave of your lordship to deal with those two documents. Those documents were never handed up to me. Though during the hearing also they were for the first time.
But he has not served you a copy. I asked Mr.
Yes,
Ghosh.
they have served me a copy, but I required to deal with these two documents. Unless these
item number 53.
53.
53 at copy to work.
My lord.
Please wait, madam. You are in this matter.
No.
If my lord may kindly seize the last order of 28th of April But I was present virtually, but at the time of my hearing, my lord, I got disconnected. Because on 28th, there was a resolution not to pass any adverse order. 29th was the second phase of the pool. On the first phase of the pool, my lord, I was all along present, but the respondents were not there. On the 28th, I was under the apprehension they may appear, may not appear, so I was present virtually. But at the time when the matter was called on, most unfortunately, my lord, I got disconnected. And that's why there was a recording made, none appears.
None appears. I've not passed any orders. I've only kept it on record.
I must bring to your lordship's knowledge that I was vigilant about the matter, but it's my misfortune.
The Basul Airport
My lord, I am appearing for item number 23 and 38. My lord, I am praying for not to be led by Mr. Trivedi. He is in court number 1.
where is Mr. Trivedi? I have asked him to come. I require his presence.
My lord, he is appearing before court number 1.
So I will come at 12. Please ask him to come at 12.
Sure. Obliged.
Number 1.
Liverpool. Yes, sir.
But we could locate someone and inform. We are sure. Oh, actually.
You are appearing.
Pilot, my senior is not today, pilot kindly. Senior.
Who is your senior?
Devjani Ghoshal, madam.
Devjani?
Devjani Ghoshal. ওটাই আমি বারবার বলছি যে কোন সিনিয়র আছে একটু বলুন দেবজানি দি জুনিয়র
Where is she? Has she come to court?
Yes, my lord, but DRT
Not yet. Let's, she's a newcomer, Milord. We ordinarily do not mention, Milord, any subordinate court rather when arguing before a superior court. Anyway, she is not here. If you notice, even in absence of the council, lordship can exercise my judicial jurisdiction. This is an unanimous notice. সকল অননুমোদিত দখলদারদের. The section 4 doesn't authorize that.
Which paragraph you are?
At the top. এতদ দ্বারা শিয়ালদা বিভাগের সকল অননুমোদিত দখলদারদের জানানো হচ্ছে যে জমিতে আপনাদের দ্বারা নির্মিত বা দখলীকৃত সকল অবৈধ স্থাপনা সোয়াংশ অবৈধ হিসেবে চিহ্নিত হয়েছে.
Now, what is your status in the property?
Look, we are slum dwellers.
You are
slum dwellers, বস্তিবাসী. আমরা ওখানে বহুদিন ধরে আছি. More than I can show you my voter card. It was issued in 1995.
Copy of the act.
Act, yes. Kindly come to section.
Do you have a copy of the Railways Act? Because I think Railways Act 147, I think for that, by virtue of that, this act applies, I think.
The Railways Act does not have any applications over the eviction is concerned.
But here it refers to Railways Act.
Yes,
Railways
Railways Act
refers to 147. Do you have a copy of that?
Aye. Kindly come to Milord 147. That is trespass and refusal to desist from trespass.
Oh. So they are invoking that. So it's a case of.
May I read out, Lord?
You have another copy?
I have below the soft copy.
Yes.
If any person enters upon or into any part of a passenger area without lawful authority and refuses to leave, he shall be liable to a penalty of 500 rupees. That it indicates the immediate and urgent power. If such person refuses to pay the penalty, he shall be produced before the competent court. And when the RPF suppose finds me that I am not encroaching the passenger area, then they can immediately get me and put penalty. Like if someone travels without a valid ticket, these provisions are there for the purpose of imposing penalty, nothing else.
No, subsection 2 says any person referred to may be removed from the railway by any railway servant
to penalty.
May call to his aid.
And conviction punishable, it requires this is simply a case that I am traveling train without a ticket. Therefore, my encroachment in passenger area without lawful authority. Therefore, I am liable for penalty. 147 doesn't have an application.
It's a mere entry. According to you, may not be an occupation. Entry and occupation.
Passenger area means I have to catch a train. I enter passenger area without a ticket. Therefore, I am an unlawful encroacher. For that, the penalty is to be imposed. But that has nothing to do with the eviction. That's why they have referred to Unauthorized Public Premises Tenancy Act. And if you kindly come to section 4, it's very interesting and specific.
No, only thing, Mr. Bhattacharya, is this 1971 Act is for a definite purpose. So unauthorized occupation has been defined. Let us take a hypothetical. So that is entry into the premises by lawful means that term or tenure expired, or
That is
there
also
may be any breach, there may be any breach of those terms and conditions during its continuance. So then it falls within 2G.
Yes.
Then if this proceedings can be initiated for eviction under this act.
Yes.
Now, if certain person encroaches upon a public property, entry was also not lawful.
Even then,
entry was unlawful. Whether in such a case, 1971 Act, all these provisions are to be complied with, or what would be the remedy then?
No, but if it is not taken research to, then they have to go for regular suit. Because the law is well certain, even a trespasser cannot be forcefully evicted. That I don't have to.
Mr. Bhattacharya, that's one way of looking at it.
That's-
The other thing is that trespasser cannot get an injunction against the rightful owner. So
No,
you can protect your possession
No,
without. That's
the possession. They are coming to evict me. I am a trespasser. They have to go to.
Possession is settled possession. Settled possession is a different
This
concept. Mr.
settled
Bhattacharya.
possession here would be applicable since I have been there for decades.
Is it settled possession?
Yes, of course, sir.
It could have defined settled possession in a different
Milord,
way
this
altogether.
settled position, Milord, vis-a-vis one.
Not only mere staying.
Milord,
for any length of time, that will not make settled
my
possession.
lord is thinking of settled possession vis-a-vis two individuals. That's
vis-a-vis
two individuals. The settled law vis-a-vis two individuals, private owners. That is at here, Milord, admittedly, Milord, these people have been, Milord, residing there. Now they say that though you have been residing, but you are occupying the railway land. What you will find, Milord, considering the realities, many refugees were settled in railway land. If today, after 50 or 60 years, say now we have to go, would that be permissible in terms of Article 21 of the Constitution? And that's why, my lord, this law says, may I read with your lordship, Lord, unauthorized occupation.
Yes, the definition.
2G, yes.
2G, yes.
In relation to any public premises means the occupation by any person of the public premises without authority for such occupation and includes the continuance in occupation by any person of the public premises after the authority whereby of grant or any other mode of transfer under which he was allowed to occupy.
Yes,
My
so
lord was
entry lawful,
but
remaining in possession after that tenure.
And the first part is for all.
First part is occupation without authority
any
for
person, yes, without authority. First is without authority, second is with authority but expired, like a government officer. Therefore, without both cases, these activities have application. And but this is not the case that they found me that I have encroached day before yesterday. The settled slum dwellers, for which we are now the courts have said you have to give.
Also, occupation of a government.
Right. So I am, but therefore the government's duty is also to ensure my shelter. I would develop argument to that extent, which follow from Olga Tiris also. That somebody,
according to you, if you have to be evicted, you have to be resettled somewhere else.
So that I cannot be made homeless. You ask me go before 500 beyond. Okay, if I do not, then you can forcefully evict me. That's my point. It requires consideration.
Yes, madam. When your senior will be available?
Monday, my lord.
Monday. But don't take any coercive steps against these petitioners. Yes, what?
No, you supplied a copy.
Yes,
This is
please take-
professional courtesy.
yes, that she has to take instructions. Ashul. let me see, because
Sure,
that is
sure,
their stand. That is why, because
Sure, I'm entirely satisfied with my last view, very balanced view.
In this matter, I'm going to interrupt. MOL is not been, the writ petition has not been served to MOL, and Eastern Railway is not the service. The writ
Asta, asta, take your breath, take your breath.
please take your seat. Please take your seat, madam.
Take your breath. Asta, asta.
Please take your seat. Please take your seat.
আরে দম নিয়ে নিন না তারপরে বলবেন আমরা পালাচ্ছি না
Sir, my lord, this matter has not been served upon MOL.
MOL means?
MOL, what is
Ministry of Law and
No,
Justice.
railway is
No more. The proper service should be done to Ministry of Law and Justice. Then Ministry of Law and Justice will appoint someone on behalf of the Eastern Railway.
You can appear.
I have not been engaged by the Ministry of Law and Justice, and my Ministry of Law and Justice has not received this writ petition. I have contacted with the Ministry of Law and Justice, and though they told me that they have not received any writ petition.
But with deepest respect, I am not supposed to serve who is not a party.
Manan,
Rail is the party, I have served the rail.
It is, I am not engaged. I don't know from where they have got the name of my name that I am engaged in this matter. I am not at all engaged in this matter.
Oh, your junior said so. We didn't say that.
No.
When I came to the knowledge, I have
not that they have
WhatsApp to my knowledge. Junior mother, junior.
That you have been engaged when this matter was moved in the morning. None appeared. They said, I asked them, they said it was served. Then I requested them to find out whether anyone who appears for the railways can appear.
I was been informed that since
can appear for the railways.
Unless and until I am appearing for the Ministry of Law and Justice, I am appearing for the railways.
So you can represent the railways.
If the
so I can
appoints me,
madam, I can direct them to regularize your appointment.
But that one can be done.
That I will do.
That one can.
That I will.
That one can be done.
That will be done.
It's not that they have said that you have been engaged. That is what initially.
But I have been informed over phone that I have been engaged in this matter.
No.
So some miscommunication.
Anyway,
ওটা একদম প্রথম
Okay, madam.
That is why because
instruction.
আবার এটার জন্য টাইম এক্সটেনশন দরকার
Instruction
যখন আছেন আপনি
regularize করেনি তো regularize করবে তারপরে instruction.
না সেটা ওদের ব্যাপার
regularized. How much time it takes for
But
regularize?
I have to give this copy of the order to the Ministry of Law and Justice, and then Ministry of Law and Justice.
How much time it takes? I'm asking you how much time it takes
Generally 1 week.
for regularization.
3 or 4. My lord, let it be fixed on 19th. I will take a regulation. I have called MOL, then I am coming here.
All right.
I've
Because
rang up
there's urgency. Otherwise, that has to
rest
be.
part of the order remains, no problem.
So 19th, I am keeping it. 20 till 20th, I have stayed this. Till 20th or until further orders. Till 20th or until further
Other
orders.
order, that's better.
I'm deep.
Mr. Bhattacharya, please take this book.
Sir.
Oh. Yes. Yes, Mr. Jha, where is?
A number of times. Last
Yes,
10 minutes back.
I think he was engaged in
court number 1.
He was engaged in courtroom number 1. Where is that? His junior was here. She came after you left. Junior of Mr. Trivedi came. I asked her to come at 12.
Right now, I got a message that I'll take 10 minutes time to come.
You have received a message.
Had it not been the discrepancy which I have shown to your lordship, the two machineries acting contrary, when the matter was filed, they were digging the soil. And now the entire boundary wall has come up. Further construction, it goes on, then the issue of fait accompli will come. They'll create a third party interest and they'll say it's in the interest of the public. And then irreparable loss will be caused.
Can you ask your junior to call? Do you know his? Oh, railways that is Mr. Jha, where is your document with regard to your title in respect of this plot?
Page 24. Page 24 is the schedule of the first document below. It's the 31 kathas property. This was purchased.
Do you know his junior?
He has called his junior. Oh. May I just go out and call Mr. Trivedi once, my lord?
Yes. If you can send his junior also, that will do.
By way of two deeds, we have purchased.
It's coming.
By way of two deeds, we have purchased the property. The one, the schedule that I have shown to your lordship at page 24.
34.
24.
24, yes.
Schedule to the first deed, my lord.
Yes.
The property.
So plot number is
Dag number 71. Your lordship will find Dag number 71.
Dag number 71, yes.
Part of that property. Next deed, your lordship will come to page 45. This property also pertains to Dag number 71. At page 46, the first line your lordship will find. Dag 71.
71. So 71.
In the two reports that we have seen, my lord, The special acquisition officer says that dog number 71 was never a part of any land acquisition proceedings.
No, it might be, but one thing is 71.
My lord.
By this deed, you have purchased how much? 1
By
bigha.
this deed, I have purchased 1 bigha, 19 kathas, 13 chatak, and 34 square feet.
Yes, and the other deed?
31 kathas.
So 31.
It sums
What
up
is the total extent of this property?
2.28 acres, my lord. That I find from the report submitted by the police authorities. They
Yes.
say that the land measuring 2.28 acres, and in block they have written 71, log number 71 full.
In the police report?
Police report. The last paragraph on the first page.
With my lord's leave, my lord. My lord, I'm junior of Mr. Trivedi, my lord. He's on his legs before court number 3, Your Honor.
You are his junior?
My lord, I am his junior.
Right.
My lord, Mr. Trivedi will come, my lord.
Yes, yes. Mr. Jha, do you have an extra copy of this? Please give a copy because now the panel has changed.
The lordship had asked me to serve. It was prepared, but the DP office is not.
My lord, I am Mr. Trivedi's private junior. Lord. I am not in panel right now.
All right, no problem. You remain, no problem.
By virtue of this appearance, you'll come in the panel. So what I was on, my lord, this report says that the entire Dag 71 in full has been handed over. And the report of the Special Land Acquisition Officer says that this Dag has not been a part of any land acquisition proceedings. In the second paragraph, the status of the proceedings, my lord. As the land is not acquired under any land acquisition proceedings.
So that is the Special Land Acquisition Officer. No, please give me a minute. Let me see. Sir, Jha, do you have copies of those report? Extra copy of those two?
I have already annexed with it.
You have annexed to?
Not that I have enclosed this here.
Yes.
Yeah.
Please show it to him once.
This is the.
There are two reports filed, one by the police and another by the Special Land Acquisition Officer. Those were filed by the previous panel. So that I have directed him to serve. You have got also a copy of this.
Much obliged.
Yes. Please give me a minute. Yes.
The discrepancy I'm showing you. Here they say that the property was handed over to them by virtue of a writ of possession. But the land acquisition officer comes and says that this land is not a part of any proceedings. So the question is, police have forcibly entered upon my property in that construct.
What is the classification of the land, Mr. Jha? What were you doing? It was from 2015. Writ of possession has been given.
It was in my possession. The property I have been.
Are you residing there?
That is a vacant land, my lord. I have my.
Where are you residing?
Just by the side of that property. No one disturbed my possession till 2025. Because my board was there. The
board of
the company. The land belongs to the company. That was uprooted. When we intervened, then they say this property has been taken by the Bazal Bazaar, by the building department. Then we come up before the court. Even an RTI was made to that effect, where they have said that the property is not vested. Page 54. Page 54. Reply to an RTI, where they say the property is not vested. Thereafter, we come to the court, my lord, seeking intervention of the court due to the police excess. Some time went on because we filed this matter before the bench taking Group 9 matters. The matter was released from there.
So you purchased in the year?
My lord, 2006, my lord. both the properties.
Yes. So where is the record of rights?
There was a dispute insofar as that thing is concerned. We made application, but that is still pending.
No, there was a record not in your name. In the name, might be in the name of your vendors. Where is that?
That I have not.
Where is the record of rights? Because what is the status of the property in the record of rights?
That I have to bring. But the record of right, insofar as record of right is concerned, my lord, that does not gives any title to the property.
Mr. That's one way of looking at it. Record of rights may not give title, but I want to see what is there in the record of rights.
What the application for recording my name before the
That's
PFR
pending.
was kept pending.
Mr. Jha, that's I
There-
appreciate.
why
I follow that.
Why
One
I am
thing is
on
that
because there was a dispute even there. They had stated that this property we cannot mutate. Perhaps they have put the property in Khotian 1. I don't know about that. It might be so. Why I am saying
Mr. Jha, if it is under Khotian number 1, then there is a difficulty.
every time entry in Khatian number 1 might not be a proper thing.
Mr. Jha, if it is under Khotian number 1, so it's a vested property, rightly or wrongly. You may say, or you may contend.
RTI says so.
It's a vested property.
No, it says it's not vested. The special land acquisition officer says this property has never been a part of any acquisition procedure.
Acquisition and vesting are different thing altogether.
I understand.
May not be acquired, but if it is vesting, then it's a different thing altogether. Please give me a minute.
My clients at one point of time, they were made to make an application for long time settlement by the BLR.
Yes, then it's a vested property.
I'm not aware of that particular part, my lord, that aspect.
That is why from whom you are purchasing, he must be also yes.
So far as the records which are before your lordship,
please,
my lord.
Please give me a minute. Let me go to this.
May I draw attention of your lordship to one recital in the deed. Lordship comes to page 18.
I'm at the recitals of the deed.
They speak of vesting. It was subsequently freed and exempted.
Yes, so admittedly there was some vesting proceedings. Now, thereafter, it says that by an order, that vesting order was set aside. And thereafter, your vendor, as purchaser, purchased that property. That's what is there in the recitals. So, there was some vesting proceedings
At some point of time.
At some point of time. So, might be for this, otherwise.
But the property, my lord, we have purchased the property in 2006.
Yes.
Be that as it may, the writ of possession is issued in the year 2015.
No, you may have purchased, Mr. Jha, if you do not have any title. If your vendor did not have any title, you cannot get any title.
Kindly see
Merely because
date of divestment, the orders of the court, 28th of March 1974.
Yes, I've seen that. Thereafter, your vendor purchased it from Sundarban Dairy, Agriculture Dairy something. So that is there because writ of possession
That's
without
an administrative
anything.
document, my lord. That cannot be used to dispossess.
If it is, there are two ways of looking at it. If it is, if you have the title, your title, there is no dispute with regard to that. It's one thing.
Had it been so, when I made an application for mutation before the BLRO, it is well within their knowledge that I have purchased
Where
the
is
property.
this? Where is this application dated 22nd of September 2022?
Page 27.
Page 52 refers to an application. Where is that?
I have not annexed that particular document.
You have a copy of that?
I have it not with me right now. I can bring it. When this came to me, I said, considering the facts, I advised my client that it was a wrong step taken by me. If the property is divested, then why did you proceed with making an application for a long-term settlement? That was a question I posed to them. That
Yes.
you have taken a wrong decision of proceeding with that. Then even with the writ of possession issued in 2015, they did not take the property to 2025. Because the lordship would find that in the report, even they say that demarcations were made by them in 24. At no point of time any notice was given to me by the authorities.
Where is the RTI information?
Page 54, your lordship.
This is RTI information is not vesting under the Estate Acquisition Act. This is vesting under the Urban Land Ceiling Act.
This is what they are saying.
No, you have applied. Your application was before the ULC.
Right, it was before the ULC.
Pursuant to that, yes, ULC has said.
This may be, the last line says, this may be treated as a reply to a prayer under RTI Act and his application is disposed of. But prior to that, however, the second last paragraph, however, this information cannot be treated as NOC of this department under any
Yes,
act.
that's not an NOC. That's one thing. But yes, your application under the Right to Information Act was before the competent authority under ULC. So that's not before the revenue authority.
No.
So,
but even the report now which comes before your lordship, that speaks that no acquisition took place. What I'll suggest,
acquisition and vesting are different things.
Subject to what is calling from your lordship. My suggestion, my lord, and request before your lordship is, considering all these situations, my lord, a limited stay be granted insofar as the status of the property is concerned. Authority should be restrained from further constructing, and a detailed report insofar as all these aspects are concerned should come up before this court, my lord. And that should, and the report filed by the authority should contain the acquisition notification, vesting documents, if any, land records, the possession memos, sanction plan, and authority for construction. Let those be covered in the report that will be placed before your lordship, my lord. That will clear up the entire scenario insofar as this property is concerned.
You have prayed for compensation here.
And the mental agony, the manner in which I was dispossessed, my lord, has compelled me to make a prayer for compensation.
By interfering with the to restore the status quo, to compensate for the damage.
Because the manner in which I have been dispossessed, it demonstrates a prima facie violation of Article 300A, my lord.
Your application for long-term settlement.
That was a wrong decision taken by the. They were wrongly guided, my lord.
That appears
that mistake.
Mr. Jha, if a person is the owner,
my lord,
of property,
my lord,
having deeds, he will not apply for
it was the
long-term.
BLRO office who instructed them to do it.
He will not apply, and it's a company, Mr. Jha.
They were wrongly advised. This is my conviction, strong conviction, my lord.
That's one way of looking at it. Company cannot be misguided in that way. It's not a layman.
Should not be. Should not have been, rather.
So the company, they will take legal advice when they are having these documents.
But that adverse presumption cannot be drawn, my lord, in my most humble submission.
And also, you have applied before the ULC for getting an
RTI.
information as to whether it's vested under ULC, but not before the revenue authorities.
Keeping that aside, my lord, keeping that aside, the report which has come up before your lordship, that is by the special land acquisition officer.
That is what I am saying. There is no necessity for acquisition in respect of a vested property. That's why, because Mr. Jha, all replies are under the Right to Information Act are pursuant to a query. So, what is the query you have made? So there is no query that it was it was vested or not. So this report says no acquisition. If it's a vested land, there's no question of acquisition. So in that manner, it's right.
Let there be a direction, because from the recitals we see, my lord, that there was an acquisition which was subsequently set aside in 1974.
BLRO is a party here.
No, your lordship.
You have not implemented the BLRO as a party.
I had filed police in action over action.
No. BLRO you have.
Yes, I had, because of the application which was pending for mutation. I had filed the BLROs.
No, BLRO is a party here.
Yes, we had made. And even the special land acquisition officer had been added as a added respondent pursuant to the directions of the court, my lord.
Yes, now the special land acquisition officer says no acquisition. So his role is now limited now. So
now we have to add another person as a party.
Now BLRO is a party.
He can say whether the property is vested or not.
Yes. Now the BLRO is a party. Yes. Where is your senior?
Lord Mr. Trivedi is still arguing in courtroom number 3.
Still arguing.
I'll beseech your lordship to grant us.
All right. I'm keeping it tomorrow. Ask Mr. Trivedi. Yes. Please take instructions. Ashwin.
I'm toiling to get an interim order in this matter. I'm toiling to get a.
Mr. Jha, it's only one thing, bit of possession in 2015 and other things at one point of time. There was some vesting proceedings. So that's, after all, Mr. Jha, if it's your property, it has been taken up forcibly, you are entitled to be rewarded back with the possession. So now the construction has started. So if the construction has started, it's a question of handing over possession to you.
They'll take the plea of fait accompli.
They will take
It's in the public
cannot.
interest.
That cannot be done because if you are the owner of the property and you succeed, either two ways.
There should be an interim protection. This entire constitutional protection that your lordship has to be granted.
They can one way. They can either they have to restore back possession to you. So without only by restraining construction, it will not help you.
For the time being, my lord, any sort of interference in the land is prejudicing my right.
Mr. Jha, you have been dispossessed. When the boundary wall has been encircled,
my lord,
you have been dispossessed.
They'll be restrained from using the land in any manner.
So if there is possession now, then they have to be ousted. That cannot be by way of an interim order.
But by way of interim order, your lordship can restrict them from even using that property.
That is dispossessing them. Cannot be done. How can it be? There are mandatory injunctions.
When it's glaring,
Mr. Jha, when it's the mandatory injunction directing them to.
My lord, in my most humble submission, an overwhelmingly prima facie case has been made out for grant of
I'm not saying
injunction. It's a constitutional protection, your lordship.
Protection is by way of an injunction. Injunction restraining them from or to oust them from that property for the limited.
I am not praying unless your lordship finally decides the matter. I'll not go into that. But there should be an order of restraint upon them from using or further constructing the property.
At the concept, Mr. Jha, what will happen? What will happen if they construct? If you are entitled to, that has to be demolished. You will get that property.
There are contrary views insofar as what is falling from a lordship is concerned. But considering the entire aspect, if two machineries of the state they are making contradictory statement, and if instruction
no contradictory, because
if the instruction comes that the property has been divested,
yes,
if that instruction comes, then
you get the property.
It is the duty of the court to dispose of the matter and hand over the property.
Yes, that is what I am saying. So if I find that they do not have any right in respect of the property, there is no proceedings, I will immediately direct that.
But that instruction should come, in the absence of that instruction, at least some protection should be given.
Only they have been.
I understand the situation.
So it's a peculiar situation. Otherwise, the report was also not coming. I directed them, I compelled them to file the report.
From July 25, I'm running for an interim order, my lord.
So now the report has come. So they have been engaged today. Let them take instructions. If I find that you have the right in the property, I will direct them.
And the entire procedure, I am losing material instructions with continuous appearances.
That's you have to do some work pro bono, Mr. Jha.
A lot of matters I do pro bono.
Yes, for that you are there.
Obliged.
Thank you.